So again, good morning, everyone. Welcome to the monthly webinar hosted by the Division of Housing Office of Rental Assistance. This month, we are going to be presenting on terminations and informal hearings, two very important functions that you do for us on behalf of our vouchers. This month, as I mentioned, Lynn Symington and I will both be presenting, and we are going to start with Lynn. So Lynn, just let me know when you want me to advance the slide. And you're up.
Perfect. Thanks and good morning, everyone. Thanks so much for joining us today for this webinar. I'll just briefly go over our agenda. Today, I'm going to speak about the participant conference process, termination of assistance, some tips and best practices, and some forms and resources we have for folks when going through the tenant conference or participant conference and termination of assistance. And then Catherine's going to take over and discuss informal reviews and informal hearings. And as Catherine had mentioned, there will be time after the presentation of just the tenant conference and termination of assistance for some questions, and then some time after the informal reviews and formal hearings for some questions. Okay. So participant conference process, what is the goal? Our goal is to keep people housed and for them to be successful in our housing programs. Sometimes, as we all know, that violations do occur, whether those are intentional, unintentional. And so the tenant conference process is a very important piece. This allows us, you, to have an opportunity to discuss violations with your participants, to clarify what the expectations are of the voucher program, and to ensure compliance and offer additional support. So we want everyone to be successful. And sometimes people, I think we all know when you do a briefing and someone's getting a voucher, they're pretty excited and maybe they haven't really digested all the information that is given. So maybe they don't understand what those expectations are. So a participant conference is a really good time to sit down and have that conversation with them. So here are some of the top reasons that we all know of why participant conferences can be necessary. And so these include failure to report income. If that failure to report income results in a repayment agreement, sometimes you're going to be getting emails from Division of Housing saying that they have failed to make payments towards their repayment agreement. Participants who have been evicted from their unit or have had criminal activity at their unit. Lease violations, moving without proper notice, having unauthorized individuals living in their unit, and then failure to complete annual reexaminations. And when you go out to do inspections, if there are tenant-caused fail items. So these are all kind of those top reasons of participant conferences. All right, so what are the steps? So you've been notified, whether by a landlord or by DOH, that there has been a violation for one of your participants. The first step is to schedule and prepare for the conference. And so I think a big thing these days is it is very important to type up a letter. I know this seems old school, but mail out that participant conference letter, both certified and via standard mail. It's very important. I'm not saying that you can't email them also or call them on the phone to discuss it, but it is important that we have that documentation and that a letter is sent out. And you want to be scheduling that conference at least 10 business days out, maybe even a little bit more. We all know how mail sometimes can take a little bit longer to get to participants. The last thing we want to do is to have that short turnaround time that they get the letter and the next day the tenant conference is, or the tenant conference has passed. So we don't want that. And so when you send that letter out, you're going to want to be gathering any relevant documentation and, if needed, prepare a timeline. You are able to add notes in Elite, and sometimes that is helpful. You don't have to, of course, but those notes in Elite can be referred back to. Your SPOC or DOH can review those notes. And so that is just a tip. If you want to use that function, you do not have to, but it is out there for you to use. All right, so step 2. Conducting the tenant conference. So the first thing you want to do is do introductions. So sometimes there might be a case manager that attends or someone else from to support the family, an advocate. So you want everyone in the room or on the phone, because as we've all kind of seen over the past few years, we can do a lot of things over the phone or by video. It does not necessarily need to be in person. And so that is an option, and it can be an option when you send out those letters, an option to conduct that participant conference over the phone. It does not have to be in person. That is not a requirement. It just has to be like a verbal tenant conference. So whether over the phone, in person, video, and you want to discuss the purpose of the meeting. You want to state whatever program violations are going to be discussed. And it's important to be clear of just what those violations are and the consequences. Again, like I've said, we want, excuse me, we want participants to be successful in our program. And so usually in the past, when I've conducted tenant conferences, that's how I approach it, is to say, our goal is to keep you housed. If the violations continue, you could potentially lose your housing. None of us want that to happen, but I think it is important to stress to them the importance of following those regulations and their program obligations. All right, so you want to provide the participant with any documentation that you have. We are never trying to hide anything from a participant. So if there's unreported income, you're providing them with the documentation we have. Is that a CBMS report, an EIV? If it's lease violations, what have you been provided from the landlord? So we do want to be very clear with what those violations are and the documentation that we've received. And if appropriate, a timeline. That could be maybe there's several violations that the landlord has submitted. And again, the documentation may include the violation documentation, and then it's always a good best practice to have that statement of understanding and other documents that indicate the participant has been informed of program policies. I know that some people may just see a form and they sign the bottom. They're not really reading. Sometimes there's a lot of forms that people are filling out. They're not really reading everything on there. So it's important to identify what the violation is, the documents that indicate here are the program policies, review those with the participant if they need clarification. And then you're going to want to provide copies of any sections of the Division of Housing Admin Plan, the Statement of Understanding, anything that clearly goes over what that program obligation that they violated. All right, next slide. And then you want to allow a participant's response. And so sometimes at the beginning of the participant conference, it's good to maybe set that tone to say, hey, I'm just going to go over this, and then you're going to have time to respond, explain, so they don't feel like that they need to interrupt or interject. Say, you are definitely going to have time to be able to discuss these. I'm just laying out, here's what has been reported and here's the documentation. So allow the participant to present their explanation to the issue and to submit any documentation that they may have. We've all seen where maybe there's identity theft. Maybe that income that's showing up is not the family's. So there could be other documentation that they have to dispute why they're there for that participant conference. And if a participant says, oh my goodness, I didn't work here, I have documentation, or this lease violation, or HQS fail, it's been completed, but they didn't bring any of that documentation to the conference, you can give them time to provide that. And we want to provide like a reasonable amount of time. And so it is very important to give a specific date of when they need to have that submitted, instead of saying, oh, in the next few weeks. That's very vague. So we would say no more than 2 weeks, and to set a specific deadline, an actual date. That is very important, just so they know. And if they miss that date, then we need to move forward with the conference process. So if that's unreported income and they say, oh, I have proof, 2 weeks go by, they don't provide that by the deadline that you provided them, then we need to move forward with that repayment agreement. All right, and this is then the time where you have that interactive discussion. You're after the participant provides their any evidence or just their view on it, to discuss what that is, the program policies, and then suggest possible ways that the participant might handle a similar situation in the future in order to avoid future violations. And so what are some steps they can take? Again, if there's a case manager, maybe they have a support system there. What can they do? And I think we do have in the attachments that will be sent out and is on our website, just some tips on how to have that interactive discussion. We don't want to be leading any participant. We want them, ask them, what are some ways that we can, make sure that this doesn't happen in the future. Maybe it's they're not paying their rent on time. And that's a lease violation. What are some steps to take? Possibly getting a payee, but I think that they have to come up with the solution. And I think we'll talk about that a little bit more in the next slides, but you could definitely suggest, but you do not want to be the one that is making the decisions. They need to, be a part of that. And you're going to want to document the conference. We do have on our website the acknowledgement of participant conference form. And so both the participant and the coordinator need to sign and date that form. And you're going to be wanting to list all the program and lease violations that have been discussed. And then this is the same form that is going to be what steps are going to occur in the future to try to make sure that these violations don't continue. So list the actions that the participant will take to resolve the situation and avoid further violations, and be specific. I think that it can be, if somebody had a participant conference for not paying their rent on time, for someone just to say, I'll pay my rent on time. We want to be a little bit more specific. What are the steps they're going to take? And we want to make sure to include information provided by the participant, kind of what I was saying. It shouldn't just be us filling that out for them, saying, oh, here, you're going to pay rent on time. What information have they provided of how they're going to ensure that any of these violations are resolved and that there won't be any future violations. And then the participant is going to initial and date the conference and termination checklist. And we are going to want the participant to sign a new statement of understanding. And I think a best practice is to highlight if there were any issues that had been discussed on that statement of understanding that they violated, to highlight those. And then you're going to want to give the participant copies of all documentation completed during the participant conference. So the checklist, the new statement of understanding, you're going to provide them copies of all of that. If you're doing this over the phone, that can be a little bit more challenging. It can be difficult. Not difficult. It's just going to take a little bit more on your part to discuss those. You are going to have to print those out, send them, email or mail them to the participant, and give them a firm deadline of when it must be returned, because they are going to need to be signing those forms and return them to you. So just make sure that if you're doing that, that you get those out in the mail, get those signatures back for your file. All right, and this is what I discussed prior is for all of our programs, whether they're housing choice voucher, emergency housing, permanent supportive, SHV, all of them. But when it comes to the number of participant conferences, this part is where it is a little bit different depending on the voucher type, and even depending on the program type, if it's a project-based or a tenant-based. So with housing choice voucher and with all of our programs, if violations continue, you go back, you follow the same steps, but maybe it's their second conference or their third conference. Our guidance with housing choice voucher is after that third tenant conference, if a fourth violation occurs, that's the step that you're potentially involving the Division of Housing. For our other programs, there is, a little bit different guidance. And so kind of the next steps are going to be a little bit more housing choice voucher, emergency housing choice, or emergency housing voucher specific. So if the violations continue, you complete the participant conference termination checklist to document the steps and timeline in Elite Notes, and then you're going to provide documentation to your SPOC and ask to review for termination assistance. And the documentation you want to submit to your SPOC is all the participant conference paperwork. That would include any lease violations, copies of all the letters that you had sent, other potential documentation. Maybe you have police documentation. There could be income reports in there if it was for unreported income. And then a big piece that I really want to hit home on is the supplement to application form. And so a lot of times folks don't fill that out, but if they do and they have identified someone that they want the Division of Housing or you as an agency to reach out to if they're being terminated or if for other reasons, we need to know that. So we're sending any communication we have to that other individual listed on that supplement to application form. I think this is key. If let's say someone has abandoned a unit, is there someone else that they listed that we could also be reaching out to? And so I think it's also really important, maybe when you're having some of these participant conferences, to talk about the supplement to the application form again and explain to participants the reason and the need behind that form is if we can't get a hold of a participant, that there is another individual that they have agreed that we could reach out to. All right, so what the Division of Housing will do. And like I said, with housing choice voucher, we usually say after 3 tenant conferences or violations, and the fourth one, submit documentation to the Division of Housing. There is no hard and fast rule regarding that. It could be one violation that is serious enough. Someone has abandoned their unit and you have reached out multiple times and there is no communication. That's been their first violation. You can still submit that to the Division of Housing and to your SPOC. And so what we will do is we have a panel at the Division of Housing that will review any terminations that have been submitted to us. And we'll review and respond within 10 days. And we want to ensure steps have been followed and the termination is warranted. So we're going to look at factors, the time between conferences, what the violation is. And like I said, a fourth violation isn't automatically a termination. but sometimes one violation, depending on that violation, is. And it can be frustrating, and I understand is that there is a lot of gray area. There is no real black and white. Definitely, this is a termination. This is not. There is a lot of gray area, and that's why the Division of Housing does have a panel. We want there to be multiple people looking at that and discussing it. And so once that panel meets, one of two things will happen. Is that Division of Housing will determine that the termination is valid, and we will move forward with that. And what that means is that DOH will mail a termination letter to the participant, and if needed, a HAP contract termination letter to the landlord. And we will mail those out. SPOC will send a copy of that to you, and then we will terminate their assistance in Elite. If we feel like there is not enough information or not enough to warrant a termination, that will be sent back to the agency with the panel's decision. All right, and now I'm going to talk about some other reasons for terminations that don't need to necessarily follow this tenant conference process. So, death of a sole household member, and a lot of these are ones that the Division of Housing is going to be reaching out to you sometimes. So, whether you as a housing coordinator hear that one of your participants has passed away, or the Division of Housing reaches out to inform you that they've received that information from EIV, Division of Housing will process a deceased or process this for the participant and send out a letter to the landlord and tenant. And so that is something that we will do. I know in the past what people have asked, what type of documentation do you need? We do not need a death certificate. We do not. It could be a case manager email that says our participant passed away on this date. It could be an obituary, but sometimes we don't know an exact date of death. We can just do the best that we can and process that termination. And one thing to note also, and I'm sure many of you know, if a participant passes away, HUD regulations state we cannot pay for any month following the month that the participant passed away. So if they passed away today, we have to terminate effective February 1st. We cannot pay any additional HAP to the landlord. And I know that can be difficult and frustrating for our landlords and owners. Another type of termination that doesn't go through the tenant conference process is a relinquishment of voucher. And so if you have a participant who says that they no longer want to participate in the voucher program, we do have a relinquishment form. If a participant doesn't send that specific form, if they send you an email saying, I'm giving up my voucher, I don't want to participate anymore, we can ask for them to fill out our form, but if they don't, send that to your SPOC. We will send out a termination letter and give them time to respond if they're like, oh, never mind, I didn't send that. I don't want to relinquish my voucher. They do have a time frame to respond if they're saying, no, never mind. But we would like that form filled out, but if they don't, please just send the information you have to your SPOC. We don't want to be wasting, weeks, months trying to get a specific form filled out. And then just a reminder, an eviction is not an automatic termination. So I've been around forever, and I feel like for 20 years, an eviction meant automatic termination for our program. That is not the case. If a participant is evicted for serious and repeated lease violations, we will review for termination, but it is not just a guarantee. And I do know our participant conference form needs to be updated because I think on the right-hand side, it says, it still has eviction on that side where it says no need for a participant conference. And one of them is like eviction, that form. And I apologize, that does need to kind of be updated because it should say eviction for serious and repeated lease violations, just not Simply an eviction. Voucher expiration. And so there's some nuance with this. If a voucher is expiring and it's for someone who has never leased up, so is an applicant, this is not considered a termination. So expiring these vouchers is done by the residential coordinator. So that is, someone is issued a voucher, they have never leased up with us, whether it's off a waiting list, SHV, PSH, whatever, they've never leased up. Their voucher expires. We are not required to follow the tenant conference or termination policies on this. That is something that's just expired in Elite. They do not have the same rights as a participant. So you hear us talk about applicant participant. An applicant is just someone who has potentially has a voucher with us, but they have not leased up. The minute someone leases up in a unit, they have different rights and responsibilities, and they are then considered participants. So for those vouchers, no letter is needed. It can be done, if you're in Elite, it can be done by you. But expired vouchers that have been issued to participants, so we think of those as kind of those issued under lease vouchers. Those we have to follow that termination of assistance process. That doesn't mean you have to go through the conference process. What it means is you would submit documentation to your SPOC, or in some cases, your SPOC is reaching out to you saying, hey, it looks like this participant's voucher is about to expire. We will then be sending out an official termination letter with, a date to appeal that by. And that's really important also if you have that supplement to the application form filled out, because if we don't have any other address, we're sending that termination letter to the last unit that they leased up. So that could be a unit that they haven't lived in for 3 months, 6 months. That's the only address that we have on file. So if you have a voucher that's expiring and oh, I have a new contact address or new contact information for this participant, please let your SPOC know. So we're sending out that letter somewhere where that participant can actually get that. All right, next slide. Some more reasons for termination: zero HAP for 6 months. And so that is a HUD regulation that a participant who is paying their full rent, so there is zero HAP for 6 full months. HUD sees that as someone has graduated from our program and they are self-sufficient and no longer need that voucher. And so in those instances, that is something the Division of Housing does. And we track those on our end. And so your SPOC would be sending that out, that letter out to you. And then we are also mailing out those letters and terminating them in Elite. And the next one is a big one. I feel like this is where we see a lot of maybe terminations and then maybe requests to overturn those terminations, is failure to complete the annual reexamination. So the DOH policy and process is to terminate anyone who hasn't completed their annual reexamination around the 15th of the month of the effective date of the annual reexamination. That's pretty wordy. What that means simply is today, SPOCs should be working on, well, this week, I don't want to say specifically today, any January annual that has not been entered into Elite, or if you're not in Elite, submitted to your SPOC, we should be working on terminating any January annuals that have not been completed. I believe, and I know that many of the SPOCs are reaching out to say, hey, this annual's not done. I'm working on terminations. And it is a lot of extra work on everyone's part to type up those letters, to send it out, to terminate. And so if you are in communication with these participants, it is very important that they have that paperwork before we process these terminations. And hopefully agencies, you guys are sending out, possibly 2 letters with packets for their annual reexamination. Division of Housing is sending out a letter saying we haven't received this. So they should have received a minimum of, usually 3 letters by the time they're getting this termination letter. And so I really want to reiterate just how important it is that we get those in on time. And that Division of Housing is making that push to make sure that we are terminating all late annuals around the 15th of each month. So we don't have a lot sitting out there. Late annuals affect our score, our CMAP score we talk about, and then it's just can affect our budget. There's lots of things that this can affect. So it's very important that that we get those annuals completed. And if they haven't been, that those participants are going to be terminated. And that's, of course, never something we want to terminate someone for, is just not completing their paperwork. So anything you all can do to help us cut down on those is greatly appreciated. All right. Last up, some tips and best practices. So I think I mentioned this a little bit earlier, and we have changed over the years our termination letters to make sure that we have a specific date for a response. I think we used to do the same thing with termination letters to say, please respond within 10 days of the date of this letter. That's not helpful. Or 10 days when you received it. How do we know when someone received the letter? So it is very important that you insert specific dates for a response. Whether it's to get paperwork back, any reason, have a specific date in there. And then track dates and follow up. So I'm sure you all have, great ways to track. I am that person that just goes out on my calendar. However, whenever something is due, and I put a note to myself. Now, whether I remember to look at that note and do anything, that's a whole different story, but that's how I track it. But it is important to be tracking that and following up. And respond to all phone calls in writing. I know that can be difficult and is an extra step. But if you get an email, a voicemail, if you're on the phone with a participant who says, my rent's changed, or not my rent, my income's changed, or I want to add someone to the household, it's really easy to say, great, get that into me in the next 2 weeks. But what you need to be doing is, even if you're on the phone with them, you can be doing this, type up that letter to say, we spoke today, or I received a phone call from you stating this. You have until this date to get me this information. I think we've seen that. And when we were all maybe working remote, it could be more difficult to mail stuff, but it is very important to have those letters when we're looking at terminations, for us to hear, well, I talked to him on the phone a lot and told them this. Well, where's the documentation of that? So it's very important that that we have that documentation and that it's in writing. We want to keep all the documentation in the file, whether that's a paper file or a digital file. Just make sure to have all of that information. Again, starting a timeline of events, you can use Elite Notes section or whatever tracking that you do at your agency. And then a big one I think we run into, if a landlord doesn't have the writ of restitution or other legal eviction paperwork, that can be a struggle. Sometimes the landlord's not providing that. What you can do is check the 3-day notice for the attorney's information, and you can request documentation directly from the attorney. I heard from a lot of people that works, which is surprising that you have better luck with an attorney than you would with a landlord, but sometimes that can be a useful tool if you're not getting anywhere with the landlord, if you have that attorney's information, to reach out directly to them. Right. Forms and resources. So as I mentioned a little bit, there's speaking points for conducting a participant conference out on our website. We have the top reasons for participant conferences and terminations. The forms out there, there's forms out there for the checklist, the participant conference. I do also believe there's letters out there for participant conferences. If not, I will make sure that we get those out there. And then a good guidance is always to use the HUD Code of Federal Regulations, and for the housing choice voucher, that's 24 CFR 982.551, sorry, for guidance. And again, like I mentioned, just to document, it is very important to have that documentation. The more information that the Division of Housing Review Panel has to make decisions, the better. So that's very important, and we appreciate, like I said, all of the work that you guys do. And I know that conferences are a lot of work, participant conferences, and that documentation is a lot. So thank you. I think that's it. All right. No questions. Yay. No.
Fonda and Kimberly have answered many of the questions. I'm not sure if we have any unanswered at this time. Of course, we'll have another opportunity at the very end. So I think I'm just going to keep pushing through. Thank you, Lynn.
Oh, of course.
Okay, so Lynn just presented on the participant conference process, and sometimes that process leads to termination. And sometimes following a termination is a request for an informal hearing. So this half of the webinar, we are going to present on what is an informal hearing. Also, we also have the informal review process that we will actually start out talking about. Just to close the loop on what we presented earlier. We're going to offer some information, and again, the attachments associated with this webinar that will be provided will give some really amazing processes and guidance on how to host an informal hearing. Who says what, at what time, what's the process for that? So that will be helpful once you have that. But first, let's talk about the difference between an informal review versus an informal hearing. So in the housing process, both the applicant and the participant have an opportunity to disagree with and appeal any decisions that, well, not any, certain decisions that the PHA makes that could adversely affect them. So for applicants, if they're denied admission to the program or their application is not accepted, for example, and for participants, if they are terminated, if their rent is not calculated correctly, there are avenues for our participants and applicants to question and ask for additional review and sometimes a hearing on these decisions. And so what we've provided here are the specific HUD Code of Federal Regulations that outline the processes for the informal review and the informal hearing. They're very conveniently located right next to each other. So if you are so inclined and love that regulatory language, like some of us do, you can find it there. But really the next several slides, as well as the handouts we have for this presentation, will put that into bite-sized and sometimes non-regulatory language for you to review. So let's start with informal reviews. Again, an informal review is offered to program applicants. And now a program applicant is someone who has applied for admission to the program, but is not yet a participant in the program. So they've come to the top of the waiting list, they've been issued a voucher, they've attended the briefing, they're searching with their voucher, An applicant is someone who is at any stage of the voucher issuance process up until they sign a lease and we process new admission, at which point they become a participant. So an informal review is not as comprehensive as an informal hearing, as you'll see in a few slides here. And an informal review is only offered to applicants when any process or any point of their assistance is being denied. So in the Code of Federal Regulations, they specifically outline decisions that are subject to an informal review versus decisions that are not subject to an informal review. It's very handy that they have it spelled out for us. So for informal reviews for applicants, there's only one decision that is subject to an informal review, and that's a denial of assistance. And of course, there's several examples of what denial of assistance can look like. Just denying their application, not listing them on the wait list in general. So when you open your wait list and you say this wait list is open for individuals experiencing homelessness, individuals with a disability, you decide which local preferences you're going to open your wait list for, and you get applications. And if applicants have completed that pre-application and did not check off the a local preference that you opened your waiting list for, that can essentially be denied. Of course, in previous webinars, you have seen examples of letters and opportunities that we give to applicants to, hey, did you mean to miss this on your application? So again, there's opportunity to remedy an incomplete application, but after all is said and done, if they just simply do not select the local preference, they could be denied even being added to the wait list. Denying or withdrawing a voucher. So if they come to the top of the wait list and you determine that they're not income eligible, or something like that, that's considered denial of assistance and something that is subject to an informal review. Refusing to enter into a HAP contract or approve a lease. There's a variety of reasons why we may not want to do that. The unit's not rent reasonable. The landlord's on the do not rent from this person list. The lease has stipulations that don't align with the program requirements, so on and so forth. And then refusing to process or provide assistance under portability procedures. That's kind of not as common, and you don't really see it on your end, but there are situations where we may not be able to port somebody out or accept a port in. And so all of these decisions, if these are adverse actions taken against an application or an applicant, they have the opportunity to request an informal review for these decisions. Now, there are also decisions that the Housing Authority and partner agencies make that are not subject to an informal review. These are generally related to established policies and procedures. So again, we have our administrative plan. If you are familiar with that, you know we use the Nan-McKay model. And the Nan-McKay model, for example, will have what's required to be in an admin plan. And then there are certain policy procedure points that the housing authority can make a decision. So what's your specific policy in this situation where HUD allows you to make a specific policy PHA, and then we put our policy in? That's considered an established policy. So even if it's not necessarily a HUD required policy, it's an opportunity where HUD allows the PHA to make their own policy for their own program. And those in cases of applicants are not generally subject to an informal review. So discretionary administrative decisions by DOH, things that we decide are going to be our policies and procedures where HUD allows us to. General policy issues, determination of family unit size under DOH subsidy standards. So if you are familiar with other housing authority programs, you may know that while this housing authority is just a straight two people for every bedroom, 2 heartbeats per bedroom, regardless of familial status, gender, age. It's just two people and per bedroom, and that's how we are going to issue your voucher size. So just like any other housing authority, we have our own subsidy standards. Those are not subject to informal review. They are what they are in the admin plan, and our households cannot appeal the determination that we make on their voucher size. Determination not to approve an extension or a suspension of a voucher. Of course, exceptions for reasonable accommodation requests always in anything that we're discussing today. But in general, if somebody's voucher has been issued for 120 days and they don't use it and they're not requesting an extension as a reasonable accommodation, we're not required to extend it. And that's not subject to an informal review. Determination not to grant approval of a tenancy. Again, we're not always going to be able to approve a unit if it's not rent reasonable, for example. That's a HUD policy. We can't accommodate that. We can't be flexible on that. If a unit's not rent reasonable, or there's another reason why, associated with a HUD regulation that a unit or a tenancy will not work out, that's the end. We can't appeal. That decision cannot be appealed. And then determination that the unit is not in compliance with HQS. That includes family size. If it's determined that the family is underhoused, there's not enough, space for the number of people in the unit. If there are items that fail the HUD required housing quality standards HQS inspection, and the families don't agree with that, it's not subject to review. So this is spelled out in our admin plan in chapter 16, specifically chapter 16, part 3. And again, we're going to have this documentation available to you for your review, but it's really nicely laid out and bulleted what we can and cannot offer an informal review for. So let's talk about the informal review process. As I mentioned earlier, it is not as comprehensive as the informal hearing process, where you have a hearing officer, you have discovery, a time for discovery, you have the sit down, you have the script. An informal review is much less in depth. So it starts with us, the Division of Housing, or you, our partner agencies, receiving a written request or any request, honestly. I'm not sure this has been updated for post-COVID days, from our applicants for an informal review within 10 days of our decision to deny them assistance. We want to give notice to the applicant. Now we're saying here with the scheduled day and time for the informal review within 10 days of receiving the request. Generally, what happens is we have completed the review and we are providing a response to that applicant within 10 days of them requesting an informal review. The informal review is completed by a person other than the one who made or approved the decision under review, or a subordinate of this person. So if you are at an agency that's large, your housing program is large, and somebody on your team has decided that this person's not eligible, their application wasn't eligible, or whatever reason, we've denied them, denied their application, or denied their tenancy, or denied whatever we denied in this applicant process. You yourself or somebody that you supervise cannot be the one that completes the informal review. It needs to be somebody else on your team. And in cases where you don't have somebody else on your team because you might be a smaller agency, or you're a one-person housing show in your in a larger agency that doesn't also do housing work, you can send that into your SPOC, and then we can handle it using our panel here. If it's a more complicated matter, if it's just as simple as this person is not income eligible, look at the income table, look at their pay stubs. We want to make sure that we are using not necessarily a third party, but somebody who doesn't have anything to gain. If they're told, you made this decision in error, and we'll talk about that a little bit later. The purpose of an informal review or an informal hearing isn't to prove we're right and to tell the participant or the applicant, see, we were right and you were wrong to request this. It's really to offer them an opportunity for to have their voice heard, to give us additional evidence or documentation that maybe we're not seeing the whole picture. And oftentimes, not oftentimes, there have been times where following an informal review or an informal hearing, we, the housing authority, learned that we have misinterpreted a regulation. We weren't up to date with a change that was made to a regulation. It's an, I hate to say learning opportunity, but that's exactly what it is. It's an opportunity for us to write our policies and our procedures that might not be correct. So the applicant must be provided an opportunity, again, to present written or oral objections to the decision made. So you didn't select a person experiencing homelessness. That was the only preference we opened the waiting list for. Okay, let me fix my application. I will check that off. Of course, when they come to the top of the waiting list, it's still on them to verify that they meet that preference. But for purposes of allowing them onto the waiting list, we want to make sure that they have an opportunity to correct whatever it is that we are denying them for. And then DOH, also through you, our partner agencies, must notify the applicant of the final decision that was made. We reviewed your application. We still find that you did not meet the requirements to be added to the wait list. We reviewed your request to increase the voucher size based on your family breakdown. And you're right, you do have an extra person that you didn't originally apply with. And so we've made the decision to increase your voucher size, whatever that decision might be. We want to make sure that we are notifying the applicant. And this all happens within 10 days of their request for us to complete that informal review. So let's move on to informal hearings. So this is for our program participants, and just for purposes of a definition, a participant is a family that has been admitted to DOH's program and is currently assisted in the program. This is an applicant who has signed a lease, has an executed HAP contract, has a new admission in our system. So they are now considered a participant. When somebody moves from applicant status to participant status, they have more protection on the program. So we talked again about the participant conference process that sometimes leads to termination. When we at the Division of Housing send those termination letters after our panel has reviewed and made sure that they're all in agreement that this is a termination, you will notice that that letter, as well as our rent change notices that come out of Elite, as well as any actually tenant conference invitation letters, will always have a statement on there that says you have the right, if you don't agree with this or any decision, sorry, I should have had it written down, you have the right to appeal and request a review or a hearing. And you may do so by contacting, and then we have whoever is assigned to them in Elite as the caseworker. That name and phone number will populate in the letter. So of course, for many of you all, that's you. So when those letters come out of the system, they are being instructed to reach out to you to start that process, to request an informal hearing if they don't agree with a decision that's been made with their housing. So that's particularly why we're having this training, so that you know what do I do? They're calling me. My name was on the letter. So informal hearings must be offered to consider if certain PHA determinations relating to the individual circumstances of a participant family are in accordance with the law, HUD regulations, and PHA policies. That's straight from the regs. That's a big responsibility. This informal hearing it feels legal, right? Are we following the law? Are we following regulation? Are we following PHA policy in the way that we're administering this program, making decisions about participants' household status and voucher status? It does feel legal, but it is an informal hearing. And the purpose of it being called an informal hearing is to clearly convey, I'm not sure that it clearly conveys, but to clearly convey that these are not legal proceedings. Most of us are not attorneys. I don't know, maybe you are. I'm not. But we must follow these structured opportunities that HUD has in place with the intention of avoiding a legal situation in the future. Again, the informal hearing is an opportunity for another set of eyes to look over a PHA decision and say, whoa, I think you missed something here, or based on what I'm seeing in the admin plan, you actually didn't follow your policy. It's to help us avoid a future legal interaction as much as it is, not as much as it is, to allow the participant the opportunity to appeal and maybe stay on the program if they were being terminated. That's actually the more important reason we have informal hearings. But I, as the director of the Office of Rental Assistance, really do like to avoid any potential legal proceedings and make sure that we've got our program being run absolutely correct, so that we feel confident when we do have to make that difficult decision to terminate somebody's housing, that we've done so in accordance with the requirements that we have agreed with HUD that we would do. So we're only going to be offering participants the opportunity for an informal hearing when it is required by regulation. We'll talk about when it is required by regulation. We're not offering it for every decision that we make because we would be doing informal hearings until the end of time. And as Lynn mentioned earlier, with participant conferences, hearings may be conducted in person or remotely. And our admin plan does specify the requirements and processes for if we are doing hearings, briefings, or any sort of interactions with our participants in a remote setting, what best practice is for that. And that comes from HUD. If you Google the HCV HUD guidebook, you will get a lot of amazing chapters that talk about things like how to process a move, how to process an annual re-exam. They just came out with the newest updated chapter on fair housing and non-discriminatory practices. What they haven't updated yet, unfortunately, is the informal review and hearings chapter. They do still have the old one out there. I can't imagine it will be much different. But I like to browse through those chapters every now and then just to make sure, again, we're doing things as HUD hopes we are doing them. And I found this statement very interesting. And that's that the HCV guidebook suggests that the purpose of the informal hearing is to resolve participant disputes with the PHA without having to take legal action. Of course, I've already mentioned all of that before, but I'd like to mention it again. We're always trying to avoid legal action. Legal action is complicated. It is time consuming. So we want to make sure that the decisions we are making are made correctly, following policy, procedure, regulation. So should we find ourselves in front of a judge or in front of the Civil Rights Commission or in front of HUD's Fair Housing and Equal Opportunity Office, three places I have found myself in the past, that we feel confident in defending the decision that we made. And so that's important. That's an important thing to consider, because any of us could end up in front of the judge, the Civil Rights Commission, or HUD FHEO office. From PHA to partner agency to individual staff. And I know we talk about that in our reasonable accommodation training as well. So to avoid that, let's make sure we're following these processes correctly. The hearing process would also bring to light and correct errors that a PHA might have made while making its determination on a particular issue. We are not always right. Ooh, that's not hard to say. It's true, we are not always right, and it's important to accept that. And when somebody brings it to our attention that we might be misinterpreting a regulation or a rule or a policy, I want to see that. I want to know, and I want to make sure. And we have a lot of resources that we can reach out to with HUD, HUD headquarters, HUD regional. We've got some fair housing agencies that we work with, I'm always happy to pose things to them to make sure that we're understanding the policies and procedures and regulations correctly. So much like the informal reviews, there are decisions that are subject. Oops, I'm sorry. Look, I've already found an error. I'm glad I haven't sent this out yet. Decisions subject to an informal hearing and decisions that are not subject to an informal hearing. A little copy and paste gone wrong there. So these are determinations that are made where a participant can then appeal and say, I would like an informal hearing regarding this determination you've made. Determination of the family's annual or adjusted income and the use of such income to compute their HAP. Determination of the appropriate utility allowance, if any, for tenant paid utilities from DOH utility allowance schedule. So those first two, we say, here's what your utility allowance is, here's what your annual income is. They participant can come back and say, you didn't calculate it correctly. I don't pay gas. Here's my lease. These are just some examples of like, I don't think you're calculating my rent correctly, where they can ask for an informal hearing. Determination of the family unit size under DOH's subsidy standards. Now, when they were applicants, they did not have the opportunity to appeal that decision, but they do now. As a participant, they can say, why do I only have a 2-bedroom? I think I should have a 3-bedroom. Now, we might come back and say, we've completed the hearing. However, you still are not eligible for a 2-bedroom, but they do have the opportunity as a participant, again, offered a little more security, a little more protection in the program. Determination to terminate assistance for a participant family because of the family's actions or inactions. Think that tenant conference leading to termination. Determination to terminate assistance because the participant has been absent from the unit. And then the determination to terminate a family's FSS contract. This is not a very common thing for most of you out there, or withhold their supportive services or propose forfeiture of their family's escrow account. That does happen. For some of our FSS participants, they do have the opportunity to appeal our decision in those cases. Oh boy, copy and paste gone wrong again. I'll fix this before I send out the documents. These are the decisions not subject to an informal hearing, not a review. Again, these are generally because it is around established policies and procedures. So you will see some very familiar reasons, and these are very familiar because they are almost identical to the informal review. And again, discretionary administrative determinations by DOH, general policy issues, the establishment of our schedule of utility allowances. We complete a survey through a third party called NELROD every year. They tell us what our utility allowance schedule is, and they do that based on actual costs of utilities in each of the established regions that we have. And so a participant cannot say, well, you're giving me an allowance of $14 for electric, but look at my electric bill, it's actually $20. It's not up for an informal hearing. The published utility allowance schedules, which by the way are on our website, just a little plug finally, are not subject to an informal hearing. Determination not to approve an extension or suspension of a voucher term, again, exceptions for reasonable accommodation requests always. Determination not to approve a unit or tenancy, a determination that a unit selected is not in compliance with HQS, and that includes the family size inspection that you're doing to make sure a household isn't underhoused or overhoused. And then determination by DOH to exercise or not to exercise any right or remedy against an owner under a HAP contract. So anything, if we decide that an owner is in violation of a HAP contract, if the inspection fails and we have to abate the HAP, anything like that, again, is going to be a HUD regulation that the household cannot disagree or appeal. They can disagree, of course. They can't appeal our decision to abate their HAP if the unit fails an inspection, for example. or if the landlord is not following the lease or the HAP contract in other ways, and we opt to terminate the HAP contract, which again is rare, but does happen. So now let's talk about the informal hearing process. We will, I'm not going through the guidance that we do have and will make available where that really, I think it's like 10 pages. It gives you, if you're acting as a hearing officer, like the script, the how to do introductions, the documentation that's needed. But we do want to provide this overview, and we do have this process on our website under the contractor tools, I believe. So this is in writing, and we might be dusting it off and updating it, but for now it is out there. So again, similar to the informal review process, the Division of Housing or you, the partner agency, will receive a written request from the participant family for an informal hearing within 10 days of DOH's decision. So let's back up a little bit. You've sent the termination letter. Per our guidance, you didn't just say you must, if you disagree with our decision, you must let us know in writing and request an informal hearing within 10 days of the date of this letter. You didn't do that. You said on this very specific date. That's helpful, right? So when somebody requests an informal hearing, I can look at the termination letter that we sent, or that was sent. I guess that would have been sent from our office as well. And I'm going to see the request that came in for an informal hearing, and it's 17 days after that deadline that was given to them. That's an important paper trail for me. I can deny that former participants' request for an informal hearing if it's for a termination, because they did not request it within 10 days. Similar to annual re-exams being completed. They get that rent change notice. They do have an opportunity to appeal or challenge the calculations that were done, but we need to see that timely. So having those dates on there is very important. But generally, these requests are going to come to you all, because when we send our termination letters, it's going to say, if you do not agree with this decision, you'd like to request a hearing, please contact this person at this agency, and here's their phone number. So that's when the request is going to come into you. And so this process is what you will follow. We've provided guidance in the past. This is another reminder. We do not host the hearings for vouchers except for our own internal VASH vouchers that we administer directly from our office. All hearings must be coordinated and conducted at the partner agency level. And so you will have to identify who the hearing officer will be. So much like the informal review, the person or persons who will be acting as a hearing officer, we ask that they are approved by DOH. We don't have a formal process for that, but we want to know who is going to be conducting the hearing. We want to make sure, like, I'm going to pick on you, Leslie, because I can pick on you because I used to work there. So Community Reach will terminate somebody. It was Leslie's decision to terminate. Leslie cannot also act as the hearing officer, nor can any of Leslie's staff who work on her program. So I would want to see, we're going to do this hearing. The hearing officer is going to be the manager who works in our residential, in office residential program. They have, they're familiar with rules and regulations, but they have nothing to do with the voucher program. That would be acceptable. CCH, I think you guys have a panel within your own agency that of staff that are not associated with your voucher program that handles your hearings and those types of things, and that's okay. So most of you have established a partner or hearing officer that we already know, and it's okay. I know there are agencies like that share. So agency A and agency B will swap. And so agency A says, hey, agency B, can you be my hearing officer? And vice versa. that's great. If you have another agency that's administering vouchers in your community, or somebody that you know that can handle like a remote hearing, we really encourage that. Somebody from another partner agency is familiar with the administrative plan and the processes and procedures. So that would be really great, but they have nothing to gain, right? If the decision is overturned or upheld because it's not their voucher program. Or if you are at a standalone housing authority with your own voucher program and you also administer DOH vouchers, using somebody from your office is okay as long as they are not also working with the DOH voucher program. So we have a lot of options for hearing officers. And when we say they must be approved by DOH, they generally have been, but if you are not sure, please do reach out to your SPOC and we can just confirm. And it must be someone other than the person who made or approved the decision or a subordinate of the person who made or approved the decision that led to the request for the hearing. The partner agency is going to schedule the informal hearing within 10 days of receiving the request for a hearing by sending a letter to the family. We want to make sure we are very timely with responding, because oftentimes it's due to a termination and the family might still be in that unit. So offering them something in a timely manner, if should that decision be overturned, will limit how long it's been since their landlord has received TAP. So we want to make sure we are conscientious of getting hearings scheduled and completed quickly. If the tenant does not appear for the scheduled informal hearing, rescheduling may occur as a reasonable accommodation only. Now, when you are scheduling a hearing for the participant who has been terminated, or who doesn't agree with their rent calculation or has another decision that they are appealing, if they do not attend the hearing that's been scheduled and they have been given an opportunity to say that time doesn't work for me, can we have another time? Then the decision stands. And we are not going to reschedule that hearing. So the decision to terminate, the decision that the rent is the rent, the decision that the voucher size is the voucher size will stand. Again, reasonable accommodation is the exception. So if there is a reason that we need to reschedule, that's fine. We will look at reasonable accommodations always. We always consider that. But we don't want to continue like we do with tenant conferences, where we offer multiple opportunities. In situations where the reason the informal hearing was requested was because of termination, we've probably already offered multiple participant conferences. So that we're not doing that anymore. Now we're at the point where we have to terminate and we have to stick to it, or we just have to stick to our decision. So no rescheduling informal hearings. Prior to the hearing, there are pre-hearing activities. Participants and the Division of Housing or you, the partner agency, are permitted to pre-hearing discovery rights. Everyone, the family and the agency, must be given the opportunity to examine documents that are going to be presented at the hearing. And I do believe our informal hearing letter that we will provide as one of our follow-up documents lays out if any documents are going to be provided and presented at this hearing, we must have access to them 3 days before the hearing, so that the families know what's going to be presented at the hearing, and so that you, the agency, know what the family is intending to present at the hearing. There's no last minute like surprise witnesses. This is in court. And actually I don't think you can do that in court either, right? There's a reason why we have discovery for hearings, for court cases, and so on. Is this so that we all are on the same page? And then during the pre-hearing discovery, just in my experience, sometimes we go, oh, well, look at that changes everything. So this hearing is canceled, the decision's been overturned. Sometimes we can solve the issue pre-hearing with pre-discovery. Let's see. So now that the pre-hearing discovery is done, we're going to actually conduct the hearing, and that's going to be done by the hearing officer The guidance is very helpful and it's very clear. The hearing officer is running the show. The hearing officer lets everybody know, you will talk to me and you will speak when spoken to. I know that sounds harsh, but there isn't interrupting. There's side A gets to present their side. Side B gets to present their side. There's no interacting when either side is presenting. Then the hearing officer allows, okay, do you have something to add, side A and side B? Everyone gets an opportunity. But the hearing officer is regulating the hearing. Again, here's very specifically the regulation that states this. Hearings are limited to 45 minutes. So it's very important that that hearing officer gives people time. We all know that coworker or that participant who will take the whole 45 minutes to share their side. We want to make sure that the hearing officer is mindful and gives people a warning, hey, you've got 3 minutes left, so that everybody has the opportunity to present. There are 4 types of evidence that can be presented at a hearing. This is also described in more detail in our process. Oral evidence, documented evidence, demonstrative evidence, and real evidence. These are all defined. Evidence is evidence, right? There could be all kinds of things that are brought to these hearings. Each party will be given the opportunity, again, to present their side. And this will all be conducted very professionally by the hearing officer. And again, when you're thinking of a hearing officer, or if you are thinking about being a hearing officer, just know that you have to be the enforcer of time limits, the enforcer of, remember, it's not your time to talk. That's hard to do sometimes, especially when people's housing is on the line and they can be very emotional and passionate. But it's important that the hearing officer is able to maintain professionalism on both sides. The hearing officer, after conducting the hearing, gathering all of the evidence, listening to both parties, will have 10 days to issue their written decision. And we also are providing a document where the hearing officer just fills in the blanks. The hearing occurred on this date. These were the people present. This was what was presented. This was the PHA decision that was being appealed. Here's the evidence that was provided. And then I reviewed the admin plan. I reviewed the HUD regulations. I reviewed the local law. And here's the determination. And it's going to be based only on evidence, not on anything that was provided to them following the hearing. It can only be based on what was presented in that 45 minutes in the hearing. Sometimes the hearing officer's determination is that the PHA terminated in error. They may find that, nope, the admin plan was not followed and this person actually should not have been terminated. That's fine. We welcome that. But the hearing officer's decision is not the binding decision. It's just, this is what my determination is of the facts, of the evidence. That is provided to the Division of Housing. And we will mail the notice of final decision to, including the hearing officer's report, to the participant or the representative. But please know that we are not bound by the decision of the hearing officer. If the hearing officer's determination is that the termination should be overturned, I do believe we generally say we'll look at the regs that they're looking at, and if it truly should be overturned, then it is overturned. But if we do believe that our decision to terminate or our decision to count certain income, or our decision to not increase the voucher size was the correct decision, we're not bound to overturn that decision just because the hearing officer found otherwise. That is no shade to the hard work of the hearing officer, which we appreciate, but sometimes it might just be a misinterpretation of the regulations. Now, what's the next steps? We often hear, I don't think I have a slide for this. If the hearing officer says, yes, the PHA terminated or made this decision correctly, I stand by the PHA's decision. Or if the hearing officer says, my suggestion is to overturn, but the PHA doesn't, and the decision stands, oftentimes our participants will say, what's my next step? Then I want the next step up. And the next step is they would have to seek independent legal counsel, generally through, Colorado Legal Services or another agency, to take the next steps. The hearing is the final step in any decision process at the Housing Authority. I don't believe there's a slide that says that here, but just know, because that is often a question we hear. Well, okay, great. What's the next step now that I didn't win this hearing? Where can I go next? And that's where we offer them various legal resources, the Colorado Civil Rights Division, the HUD HEO office, the Colorado Poverty Law Project. We offer them as many resources as possible. We encourage you to do the same, just so they know that there's still options for them to seek an appeal. It just isn't through the voucher program anymore. So that's the hearings in a nutshell. If you've sat through a hearing, if you've administered a hearing, it's not that simple. So we do have resources that we will be providing. Our process sheet, which is already on the website, but I mentioned I do think I need to update it. Our informal hearing guidance, which is a product we borrowed from an agency after attending their training with their permission, to provide it to our partners, just the best practice of how to run a hearing. Very helpful guidance. If you are new to informal hearings and you've been asked to act as a hearing officer, or if you're old to informal hearings and you wonder if you're doing it the way you should be, it's very helpful guidance. Again, I will refer you to the Division of Housing Administrative Plan, which Chapter 16, Part 3 outlines our specific policies and procedures related to hearings and reviews. And also, coincidentally, the HUD guidebook, HCV guidebook on hearings and informal reviews is also Chapter 16. We'll provide that as well in the handouts. Are there any questions that could not be answered before we move on to some updates?
Nope, it doesn't appear so, unless someone has one right now that they haven't put in there.